Hold on. What did I just do here? There we go. Kathy Griffin blocked me on Twitter. Okay, hold on. I'm all crooked here. Hold on 1 second. I'm not crooked. I was just crooked because of that. There's so many jokes in the chat, and I don't even know where to start. I can't even do it. Hit the like button. That's even worse. Touch the like. Click on the like button or the thumbs. I don't really care. Kathy Griffin blocked me on Twitter, and I gotta tell you something. I've been sometimes I'm a sassy prick. I still think it's good humor. I still think it's good humor, but I can acknowledge that sometimes I'm a little sassy and a little rude. But Kathy Griffin blocked me, and I've got to show you the timeline. I don't know if I'm going to be able to see the timeline. It wasn't even that bad. I swear to you, like I know when I call someone, I don't call people jackasses. What did I call someone? An abject idiot. I did, but I justified it. So it wasn't just a troll insult. I substantiated my ultimate conclusion that the person who said, meanwhile, those January 6 protesters are sipping margaritas on some beach in Florida, I gave the evidence, I gave the argument to arrive at my conclusion that the person who said that was an abject idiot. When it came to Kathy Griffin, what did I say? I know what I said. She posted a picture. I'll preface this. Everyone can do whatever they want with their bodies. Oh, I can't see the tweet anymore. Oh, there. No, we can. Hold on. We could see it real quick. She posted a picture of her. It's very interesting. Flexing her muscles. I mean, we'll see it on her feed. Here we go. This is what she posted. Fourth boosters, and I think that says friskers. If I'm not mistaken, no, that doesn't make sense because there's only 2 asterisks. It says funkers because the people who she dances with people. So fourth booster funkers. Oh, and CVS gave us 8 free COVID tests for getting boosted. I think I'll see I won't see it because she blocked me. And I simply said in my retweet of her tweet, serious question. Well, why do you think that people care about your vaccination status at Kathy Griffin? Serious sass-free question. That was my question. I then went into her Twitter feed and I said afterwards, after some thought, that I have now come to the conclusion that people who flex, pun intended, their vaccination status, they think other people care about their vaccination status because they care about other people's vaccination status. And I said, well, here's what I said to Kathy Griffin. Why do you think anyone cares about your vaccination status, Kathy Griffin? Serious, sass-free question. And it was. Why does she think it's like, I'll admit, I post selfies. When I catch a fish, I post it sometimes, depending on how big it is. If it's this bad boy right here, caught off a kayak, by the way, I post it. I can appreciate that some people don't care. I still think it's interesting to anyone who's into fishing. So someone posting that they got their 4th boosters, effers, they're posting it because they think other people find it interesting, or because they think other people find it interesting because they are interested in it in other people. And then the other tweet response was, then I went into her feed. And I think that's where it becomes something that people block. Here we go. At this point, my conclusion is that people like Kathy tweet these idiotic I got vaxxed boosted posts because they think other people care about their vaccination status because they care about other people's vaccination status. Spoiler alert for a great many. I don't care. I never will care. It's none of my business. And that's that. Blocked by Kathy Griffin. My goodness, she can take a picture of her holding, a wax, you know what she did. I don't even want to say it. But hold on. Yeah, dude. Viva's face with that fish. That was hands down the biggest pike I've ever caught. Caught it off a kayak, but not a fishing kayak. Like one of those Costco Pelican kayaks. And I'm not complaining about it. It's a beautiful kayak. It's my mother-in-law's and out in the townships. But I was not equipped to handle that fish. Oh, such a beautiful fish. Anyhow, so that's it. Blocked by Kathy Griffin, the woman who's got a very high threshold for what she demands of tolerance for her own behavior. Apparently, I crossed that line with that question. This is Lafroig, because I found tucked away somewhere. It's like if you enjoy putting out a match in your mouth. You know when you're a kid and you light a match and you put it out in your mouth, and it's like the coolest trick ever because it goes out due to lack of oxygen, and you're left with that sort of fiery, smoky taste. That's what it's like, minus the burnt upper soft part of your palate, because when you're a kid, you do stupid things like put out matches in your mouth. Okay, so with that said, standard disclaimers. Let's just see if we're demonetized already. It's been 4 minutes and we're demonetized. This video is running limited or no ads due to a content identified as not suitable for most advertisers. It remains fully playable and is eligible to earn subscription revenue, and I shall ask for a review. By the way, everybody, this is there's something going on in the algorithm verse. This has been happening systematically with every live stream that I've been doing. It gets remonetized afterwards, and there's, you know, I'm not saying it to create drama or to ask for sympathy. It's something is up in the algorithm. It gets demonetized. We're 6 minutes in for no reason. It gets remonetized afterwards, but it's fun to. Oh, the price of freedom. No, sorry. The price of freedom is eternal vigilance. What is the expression? The price of liberty is eternal vigilance. Oh, yes. We're simultaneously streaming on Rumble. Where's my phone? Just to make sure all is good there. This is amazing because David Anber is the attorney representing Randy Hillier. I'm not doing that to be funny. I actually have I don't do it to be funny. So Randy Hillier, the Ontario MPP, who is now facing criminal charges. There we go. We're on. We're live. 500 watching. Booyah. So David Anber, who you might remember from such live streams as walking on the street at one point during the protests in Ottawa, came on to discuss a number of the Ottawa protest legal issues. Ottawa attorney. I believe he can practice criminal law in Quebec and Ontario. In fact, I know he can. He's representing a number of the convoy protesters, people who are facing charges, including that elderly man, 4'10", who was assaulted by the police officers during his arrest. He's representing a lot of the people. He's representing Randy Hillier, the Ontario MPP, who has been arrested, released, and we're going to get to this, on charges of, what were they? Some of them were nonsense, inciting to commit an uncommitted felony. The big charge was assaulting a police officer. We went over all of this earlier today. I posted the 16-minute clip on Viva Clips. If you're not yet subscribed to there, go ahead and subscribe. It's Viva Clips, and it's where I put clips from Viva Frei, hence Viva Clips. He's coming on. He's going to talk about it. I was able to catch the last hour of the hearing on phone. I was able to phone in. There were over 150 people listening on phone Zoom and interweb Zoom. They demonetize, so we do our part to remonetize, but they remonetize it, Jeremy. It's just like I guess I'm in the bad books, the initial bad books, and then they review it and see that they're maybe they're tracking words, and so when they hear certain words, they presume there's certain video images, and then when they just go see this mug in the basement talking law, they say, oh yeah, okay, fine. Today's earlier stream was demonetized after 5 minutes, remonetized afterwards. And yeah, so that's it. It's funny. I only care about what happens when YouTube demonetizes something. It suppresses the growth, obviously, because YouTube has a vested monetary interest in promoting the stuff. Yes, it's off now. I saw that earlier. They have a vested interest in promoting the stuff that's monetized. Anyhow, so that's it. Viva, did you clip where you gave me a bit of poop? Penny K, LOL. No, but you could, Penny, you could clip it. Everybody should understand, if you post a mean comment, you post a comment. I'm not out there to humiliate, lambaste anybody. There's a certain element of humor in when I dissect someone's comment. If I find it, interesting enough to dissect, insightful enough to dissect, or sufficiently lacking insight to dissect. So, Penny K, I do think I recall the comment. The stuff is monetized. Okay, stop it, boomer boy. Okay, so all that to say, I caught the last hour of the hearing today because Randy Hillier turned himself in at 7 a.m. CBC ran, exclusive, just released the charges against Randy Hillier at 8:05. The press release was issued at 8 o'clock. I see Anber in the background, and I'm not going to keep him waiting for more time than I have to, except to finish the sentence. Dave, I'll be with you in a second. Heads up. So Randy Hillier was in court today to determine bail hearings. And from what I understand, there was an agreement on all points except for one point. And the, what do they call them? The officer of the peace, Dave will correct me on the terms. They had to litigate that. And the officer of the peace, the justice, whomever, had to render a decision on the one disputed element of the terms of release of Randy. And I got to hear it, and I took notes. Which I'll go over as we get in here. Bambuga in the house. Bambuga, thank you very much. Okay, let's do this. I don't want to have Dave waiting for too long because I know he's an actual practicing attorney, not a commentating attorney. Dave Anber, how goes the battle, sir?
Doing well. How are you?
Good. Well, the funny thing is, talking to you is one thing, but hearing you when I'm listening to a court hearing, it's like it's a different world. You realize that you're not just a person, you're an actual practicing attorney in court fighting the battle in real time. I mean, I guess, where do we start on this one?
Well, I guess I started my day at 4:30 this morning when I, as is often the case, I woke up having a dream about arguments I might want to be making in this bail matter. And so once I wake up with that in my mind, I can't get back to sleep. So I was at work about 5 o'clock this morning, starting to prepare for, we knew this was coming from yesterday. I spoke with Randy, and I spoke with the officer, the detective, and the understanding was Randy would turn himself in around 7:15 this morning, which he did. And then the question is, would it be a bail hearing like Tamara Leach or like Barber or like Pat King, or would it be a consent release like many of the other people who were charged with offenses? So that was the $1 million question. So
before you even get there, I've got $1 million question. How does it come to be that Randy Hillier on a Sunday, who tips him off that charges are about to get pressed and that he'd better turn himself in tomorrow morning? How does that even happen?
It's actually a pretty standard procedure. Police want to try and limit the amount of work they have to do. I mean, they're very busy, of course. And so when an investigation has reached the point where officers conclude they have reasonable and probable grounds, the standard which they need to arrest somebody, they'll usually reach out to the person and say, hey, we just want to let you know we're going to be charging you. Can you come in at a scheduled time to get the charges? In some cases, they'll let them know and say, we'll be releasing you right away. In other cases, like in Randy's case, the police said, we will not be releasing you right away, but we want to get you to a justice of the peace or a judge that same day. And so the idea is that if a person voluntarily turns himself in, the police don't have to go through the step of getting a warrant. So it's easier for everybody to do it that way.
I'm going to read this. No nonsense. Wow. A lawyer who cares so much. He has dreams about his arguments. The type of guy you want on your team. It is. David, this is very funny. You should mention it. And everyone in the chat might find this funny. I had a dream last night about Nick Rekieta. I swear to you. I woke up and told my wife, I just had a dream about Rekieta. We get enveloped by whatever our bubble is at the time. I mean, it's a good thing. It's a bad thing to actually have dreams about your cases, because it means you are 24/7, and I mean literally 24/7, absorbed by your cases, which means that you don't actually, even when you're sleeping, get the respite, the psychological break that you need. But it is passion, and it's commendable, and I do think it's a good thing.
Oh,
so you're dreaming about the case. You know this is coming because Hillier gets tipped off.
We spoke on Sunday, so I spoke with Hillier. I spoke with the detective. We knew this was coming. So this morning I got to work looking at the law and also trying to find some case law on certain elements of this case, because this case is a little different than some of the other ones. I mean, it now turns out, now that I've had a chance to see the charge sheet, which is sort of like a very summary compilation of all of the allegations, there are a number of charges that are very much like a lot of the other charges, basically accusing Randy Hillier of participating in the Freedom Convoy, of encouraging people to show up at the Freedom Convoy, at telling people not to leave when officers were telling them to leave the Freedom Convoy. And so we have some of those offenses which sort of hinge on the illegality, so to speak, of the Freedom Convoy itself. And a lot will be debated over whether or not the Crown will prove that. But certainly the Crown feels they've got a good case, and that is the basis on which they've been bringing the charges against so many. But Randy Hillier has a couple other charges in addition to those sort of three that I just mentioned, participating in, encouraging other people to participating in, and also deterring people from leaving. Randy has this allegation that he encouraged people to tie up the 911 lines. And there's this other allegation that he assaulted a police officer when he brushed him or touched him with a barrier or made him feel intimidated to not intervene. And so he was charged with obstructing and with assaulting that officer.
I was trying to pull up the tweet, but I can't find it right now. It's not worth it. But the charge sheet to which you refer, is that what the CBC journalist tweeted out at 8:05 this morning?
No, what happened was, so the police, and this is, I'm sort of going to take you through the day, okay? So the police, when their investigation is concluded, or at least the initial phase of the investigation, because it can always continue, they will do up a few documents. One of them is called a charge sheet. It'll have, first of all, a file number on it that is appropriate to the file number before the court. It'll list the charges. It'll also list the synopsis of the facts for each of the charges. Now, that wasn't done early this morning, which I was expecting it to have been done. Now, the police did themselves settle on what charges they were going to be relying on. And that's what they tweeted out themselves and put out in a press release. And that's what the media caught on to. So it contained the charges that would ultimately be in the charge sheet. But the charge sheet wasn't done until into the afternoon. And that was what some of the delay was. I was getting calls and emails throughout the day from various media outlets who wanted to be kept up to speed. And I made contact with the Crown early in the morning, and we had some very tentative discussions about what might happen. But I would need to see that charge sheet before we could really move forward with any real discussions. And for reasons that I'm not entirely clear of, and which also includes reasons that I might not be able to get into really, at least in this format right now, is the charge sheet wasn't provided until the afternoon, sometime after 2:00. And it was around that time that I also then accelerated the discussions with the Crown prosecutor. They sent me a draft of the terms that they wanted to include based on the discussions we had in the bail. So that was sort of early, let's say 2:00, just after the lunch break. And I went through the conditions, and I went through them with Randy on the phone. I called him up at the cell block, and I went through the conditions with him. And I mean, some of them were, I think, straightforward: reside at a particular address and not change the address without permission or without notifying the officer in charge. So some of them were a little more onerous. For example, he can't enter the city of Ottawa. I mean, the downtown core in particular, between Booth Street and the Ottawa River, north of.
Hold on, actually, before we get to that, let me just bring this up, and you'll tell me this. What we're looking at right now is this for immediate release. This is not the charge sheet, but the press release coming from the police.
Right, that's a press release. And just again, I'm not able to, because the charge sheet forms technically part of disclosure, and disclosure can't be publicly shown. Okay. So I'm just going to try and describe it for you. The charge sheet will have the file number at the top right corner, and then it'll list each of those charges that you have in bullet points on the screen there, but it will list it in the formal wording. So it'll say something like that on or about between the days of January 20th and February 20th in the year 2022, Randy Hillier in the city of Ottawa in the East Region did commit the offense of mischief to property exceeding $5,000. So it'll have a long form wording of each of the charges. And then after it lists the 9 charges, it'll then summarize the facts and connect those to the 9 charges.
Something like, I say, not like an indictment or a grand jury indictment, something where they lay out the more substantive allegations, but still not full disclosure. Right. But let me just ask you this, because I was looking at this morning, and I'm not a criminal lawyer. I can just surmise the X1, X2. That means times 1, times 2 charges for each of these specific charges. All right. And so Dave, I'm going to ask you the questions, and if you can't answer them, you'll obviously tell me. The mischief, obstruct property proceedings exceeding 5,000, clear enough. Counsel an uncommitted indictable offense, clear enough. Mischief, obstruct property, the same one. I don't know why they have two of them, but I suspect it's two different occasions, but maybe we can set that aside.
Well, if you want to be, I can actually just quickly go down to chart sheet and see if it matches up with what you have to give you a little bit more.
Okay, hold on a second. Your audio. Did Dave's audio, for anybody listening, start glitching out? Dave, let me hear you. Let me hear you talk again.
Yeah, I'm here. Can you hear?
It's your audio seems to have gotten bad for me, but let me see if it is bad for other people. Yes. Are you plugged into anything?
I don't know. Can you
Try to. Yeah, he's glitching. Okay. Try. Are you just using your computer audio?
Yeah.
Now you're muted.
Can you maybe take it off the screen that you have with the?
No. It's good. It's good now.
It's
good now. It's better now. I can hear you. You're fine. I think your computer was shaking or something. What did I just do? I just lost it. For goodness sake. You're talking about boomer audio. It goes from boomer audio to boomer me. The one. Now you're it sounds bad again. Okay, but hold on, we'll see. Just the charge that I'm interested in, and the one that takes time to investigate. Assault peace officer or public officer.
Yeah.
So now I'm going to bring this out, and just maybe that was what was going on with the audio, but I doubt it was. That's the one. Now, I said this morning when I'm just, hypothesizing, how can it be that it took 30 days plus to bring the charge of assaulting a police officer or intimidating? I mean, these are things that you know the moment of. And I said, hypothetically, they had to fish through video surveillance or video footage to find a moment where something happened, like, oh, now we can lay that blame on Randy Hillier. I listened.
Well, I'll give you a summary of charges of counts number 6, 7, and 8, which is
okay, hold on.
Obstructing an officer.
Hold on. Now you're totally glitching out.
You want me to
log out and come back in. Okay, let's see if this works. That's we're not even going to live with that. That's worse than James Top marching through Canada. So it seemed, just to fill in the blank for anybody who wasn't watching, earlier today I hypothesized that the only way that you can come out with an assaulting a police officer 30 plus days later is if it was so obvious at the time that you had to go fish through video surveillance in order to hear it. And listening to the officer of the peace hearing, and I took notes, which is not unlawful, and I'm not rebroadcasting any portion of it. I'm just going to go to my notes that I took. It turns out that by the sounds of it, the assaulting a police officer had to do with a barricade of sorts. Let's see if this is better. David?
Can you hear me now?
Beautiful. Okay. So, yeah. Now, I was just telling the crowd what I heard during the hearing, where it turns out that the hypothesis of the assaulting a police officer, the absurd hypothesis as to how it took over 30 days to come down with that charge, seems to be something accurate, that they had to fish through video evidence to determine that charge.
Well, let me just walk you through. So counts number 6, 7, and 8 are the ones that deal with that incident. It's an obstructing an officer, Chamberlain, an assaulting that same officer.
Dave?
Yep.
Audio's, it's not working. Can you come on? Can you do it on your phone?
Let me try that.
Do it on your phone. It'll work. So, yeah, it's not unlistenable. It's unhearable. And I'm not blaming. I think I think his computer is glitching. It's not, it's not a connection issue. Well, in the meantime, we're going to take a joke from the real Bamboon guy. It says, for those of you who are wondering, yes, Viva is being sarcastic, suggesting that it took 30 entire days for a police officer to realize she'd been. Well, that was my whole point. I said, all of those other charges, I can understand it took 30 days to investigate. Some of them dealt with social media posts, which we're going to get into. The one I said made no sense as to how it took 30 days was assaulting a police officer. That happens, you're in cuffs the moment of. Oh, and I said earlier today, like, oh, did he pat a cop on the shoulder and say, good job? And they're like, oh, that felt like assault. And that's actually what it sounds like it turns out to be. Let's see here. David?
Yes.
Oh my God, is that so much better? Not only is it better, I think the image is better.
All right. Well, there you go.
All right. All of a sudden, everybody in the chat is a computer engineer. It was off. I think it's your computer, but it doesn't matter. All right. Now I'm just going to get totally neurotic. Tilt your camera down.
So I'm
a
going to
little bit.
try and recap what I've said a few times and see if I can get it right this time.
Do it.
So counts number 6, 7, and 8 is the incident involving the two officers on Parliament Hill. The allegation is that in the early or late morning with Maxime Bernier and other participants, Mr. Hillier wanted to enter Parliament Hill with a bullhorn, and was told by the officers that he couldn't bring the megaphone or the bullhorn in. And the allegation is that there's some dispute that Mr. Hillier allegedly moved or threw the metal gate. I mean, it says through, but that's really not consistent with what we see in the video. And that the officer felt threatened when Mr. Hillier basically suggested, as the charge sheet indicates, to sort of let it go. So that's really where the assault and the obstruct officers come from. It's from that incident.
Dave, I mean, I know you're going to, at some point, if this goes to trial, you're going to cross-examine that police officer.
Mm-hmm.
Have you any idea if in the moment that officer felt assaulted or felt intimidated? Or is this, hey, let's go find some video evidence. Oh, there, it looks like he nudged somebody with his elbow. Go find that officer. Wink, wink, nudge, nudge, the sinister side of corruption.
Well, it says he was physically intimidated and felt that continuing to try and get the megaphone would result in an assault. So it's written in a very tentative manner. And again, this is the words of the investigating officer summarizing what he understands the evidence to be. So I have not seen the full disclosure. Okay, so I've not seen the full evidence. So certainly we're at a stage, at the bail stage, where we get a very limited understanding of the facts right now. But the video I've seen does not disclose Mr. Hillier committing an assault of any kind. And Mr. Hillier certainly denies committing an assault. So those three charges right there are adamantly denied by Mr. Hillier.
And look, people are going to accuse me of being too friendly with you, but the bottom line is I don't believe those charges, period. I said jokingly, assaulting an officer or intimidating an officer, you're in cuffs the day of. An officer saying I felt intimidated to take a bullhorn away. I'm sorry, officer. That's your job. If that's what you think your job is at that moment, you're like, oh, I'm not doing my job anymore because I feel intimidated by a member of provincial parliament with a bullhorn. And then a month later, ring him up on charges of assaulting and threatening a police officer. That's bullcrap of the highest order, in my humble opinion, David.
My take on it is this, that when the tweets came out that many construed as Mr. Hillier wanting to encourage people to call 911.
We're going to get to that.
When that happened, that upset a lot of people. I could see how, if that is what happened, if Mr. Hillier did encourage people to call 911 frivolously, that there could be a charge there. I mean, the facts are such, Mr. Hillier does not agree that's what he was trying to do. Phoning the non-urgent lines of the Ottawa Police is a very different thing than calling 911. But when that happened, a lot of people were calling for Randy Hillier to be arrested. And so the police began investigating, and I think what we saw is they looked for some more to add to the mix. So that's when you see this incident involving the two officers on Parliament Hill, and that's when you see some of the more generic Freedom Convoy encouraging the Freedom Convoy, participating in the Freedom Convoy, not leaving when being told to end the Freedom Convoy, when we see those generic charges as well. So with those generic charges, the charges on Parliament Hill, and then really the impetus to all of this was the allegation that Randy Hillier encouraged people to call 911.
Well, we're going to get to that in 1 second. So, let's break it down. I'm not going to bring up, you know what, I lied. I'm going to bring it up again, just so we can look at this one more time, to the extent we're not bringing it up because I closed down the damn window. Those charges, there's 9 of them, give or take, broken down in threes. 3 are basically encouraging people to commit.
I can tell you this. Okay, so count number 1 is I'm just going to go through this really quickly. Count number 1 is his participation in the Freedom Convoy. Count number 2 is encouraging people to participate in the Freedom Convoy. Counts numbers 3.
Well, hold on. Let me stop you there so that everyone appreciates this. To participate in the Freedom Convoy, they have labeled that as counseling to commit mischief, correct? Because they're basically saying, by virtue of the press release from the police, used the word illegal to describe the protest.
The participation one is mischief exceeding $5,000. That's partaking in what they call an unlawful occupation. The second count is counseling an uncommitted indictable offense. That's encouraging people to join in the Freedom Convoy, bring vehicles, and attend the occupation as they've described it. Count number 3, 4, and 5 all address this allegation of Mr. Hillier allegedly encouraging people to make frivolous calls to 911.
Okay. Oh, stop there. We'll just tackle that now, because that is the biggest beef that the general public has with Randy Hillier. They're saying,
right.
He tweeted, I could not find the original tweet. Do you know what the original tweet said, setting aside interpreting it?
Again, I have not gotten full disclosure, and so I'm going to speak in a very tentative fashion based on information known to me at this time.
I love it, and everyone should appreciate what you're basically saying is, let the Crown show me the tweet to which they are referring when Randy Hillier allegedly said, drown in 911 emergency line with fake calls to flood the system. Let's see what tweet they're claiming said that.
Is the interim chief Bell, who, by the way, and this is part of the context, I've been critical about interim chief Bell before, but Chief Bell made a number of public statements in which he overstated the power that he had and overstated the power that the Ottawa police had, and made some very bold and frankly unjustified or unwarranted statements. And one thing he said, and this is probably a good example of it, he said, we've been getting some calls to 911, don't do that. But we've also been getting calls to the non-urgent line, don't do that either. And Randy Hillier's text message or tweet allegedly responded to that, and it said something to the effect of, keep calling. In a democratic society, you can keep making your voice heard about complaints.
Dave, I'm not asking you as his attorney to confirm that this is or is not the tweet. But I finally think I finally found it. Do you see this without commenting? You don't know what this is, but just do you visually see what I'm bringing up?
I believe that is the one that I'm just looking at it on my phone there. I don't
even need you to let the Crown make their evidence. Yep. I'm just saying I went to someone's feed. You're unable to view this because that means I've been blocked by someone else and I don't even know who or why. But
well,
Ottawa Police.
This is exactly what I described. Is the Ottawa Police tweet refers to the two things: the don't call the emergency line and don't call the operational lines as well. Is that what that says? I'm just trying to look there.
Yeah, I can't see the full thread of the Ottawa Police.
Stop calling critical emergency and operational phone lines. And so I think there needs to be a distinction there. Is Chief Bell may very well have a point when he says, people who are calling 911, the critical emergency line, to report complaints about police officers, don't do that. But he's also saying a second thing in his tweet. He's saying don't call the operational phone lines. And frankly, it's really not his place to tell the public about calling the non-urgent operational lines of the Ottawa Police. There was a considerable amount of police misconduct that took place under his watch. The Ottawa Police and the assisting police forces were out of control on February 18th and 19th. People in the public most certainly had a right to express their horror, to register complaints. And I think that a distinction needs to be made that yes, I can see a police chief wanting to urge members of the public not to use the emergency lines, but he does not have the authority to tell people that they can't voice their concerns about police misconduct to the non-urgent lines. And so the Crown needs to establish not just that a guilty act took place, but that it was accompanied with the guilty intention, the mens rea. And Randy Hillier will have an opportunity to testify. He doesn't have to. He doesn't have to prove anything. The Crown has to prove he had a guilty intention, but he will have an opportunity, if he chooses, to explain what his intentions were. You see in the tweet that you put up earlier, it's not punctuated properly.
You beat me to it. I was going to say Randy Hillier's biggest crime right now is grammar. Keep calling in a democracy, expressing yourself as a fundamental freedom. Okay, we know about the Oxford comma. I think what he meant was, what he probably meant grammatically. Keep calling, period. in a democracy, expressing yourself is a fundamental freedom.
Right.
Can we like, I'm not asking you, Dave, to confirm or deny. You don't know yet what the Crown's evidence is. They're going to disclose that from what I heard on or about April 4th, if I'm not mistaken. Okay, forget that. Well, when do you get full disclosure of the Crown's evidence?
Well, the next court date's May the 4th. So between now and then, the Crown will have to get me the full disclosure, because the intention is for me to have a meeting with the Crown prosecutor to get preliminary positions as to what they would like to have happen in this case.
Okay, and now I want everyone out there to appreciate that when people were saying Randy Hillier told everyone to call in 911 to flood the lines,
yeah,
until proof to the contrary, this is the tweet to which they are referring.
Right. He doesn't.
I'm going to read. There's Ottawa Police says, we know the events in Ottawa are upsetting. Still, we're asking people to stop calling critical emergency and operational phone lines to express displeasure about the police action. Yada, yada. We don't see the rest. Right. Keep calling. In a democracy, expressing yourself is a fundamental freedom.
Yes.
That's
the Crown, to have any hope in hell of proving this charge, would need to establish that Randy Hillier was specifically referring to the emergency operational lines and that he was intended to be taken seriously. No, I'm drawing a bit of analogy between the law here and the law of threats, because there isn't a lot of case law here, but I imagine the Crown will need to establish that his comments, he intended to be taken seriously, but they'll also need to establish beyond a reasonable doubt that he wasn't referring to the non-urgent operational lines. That's at least my perspective based on the information available to me at this time.
Now, and I'll tell you one thing, because it's not to let Randy off the hook. When I was there, and it was actually the day the poo-poo hit the fan and my car got towed, and I didn't even know who to call. And so I called 311, couldn't get through. I went on a loop and then it disconnected me. And then I called 911. And I always do this when it's not an emergency. The first thing I say is, this is not an emergency. But I was on hold with 911 where it ran me through an automated voice message 4 times before it finally got through. So it is a big problem to advise people to call and wrongly call in 911 so that people who actually need emergency services can't get it. The question really is here. That's what we were told Randy Hillier did. Keep calling. In a democracy, expressing yourself is a fundamental freedom. In response to that tweet, it will be up to people out there to determine whether or not that says what the media says it says, whether or not the media saying it says what it may or may not say is honest or dishonest, and ultimately in a criminal court of law, whether or not what Randy did here is beyond a reasonable doubt mischievous conduct to begin with. So, okay, it's just ridiculous. But so what happened today? So you get in. We're going to go over the terms of release, which are now public. You agree with all but one, which had to get adjudicated.
So middle of the afternoon, we're probably approaching 3:00 at this point. I finally get the draft of what the conditions are. And like I said, it included a number of conditions that were, not ideal, but I spoke to Randy and he was prepared to abide by them. But the one that stuck out to me, based on what he's told me, obviously based on his role as a member of the provincial legislature, this idea that he cannot participate in or post on social media about the Freedom Convoy, but also about vaccine mandates and mask mandates.
He's a sitting politician. He's a member of provincial parliament. And these are the terms that the Crown, who arguably has abusively arrested him on trumped up bogus charges, now wants to limit his speech as a sitting member of provincial parliament. I'm sorry to get outraged, Dave. I know you're probably innerly outraged, and I have the freedom of expressing my outrage. This is outrageous.
Let me a little bit, because some people have a hard time getting their head around this. Okay, when I wrote back to the Crown, my position was essentially the position that was litigated on the record, which is that we actually, and Randy signed off on this on the phone with me, is that we agreed to allow limiting his participation in the Freedom Convoy or support for the Freedom Convoy and posting about the Freedom Convoy. And let me explain a little bit of the rationale, because a lot of people who responded to the tweets today seem really upset about that. And let me explain why, even as the defense, I would do that. It's actually...
Hold on. They're calling you controlled opposition. You're throwing Randy under the bus. You're the enemy. You're agreeing to limiting his freedom of expression. Those types of allegations?
Maybe not to that extent, but there's allegations like why would that even be a thing? And in the bail process, okay, it's not unusual at all. And again, I'm not saying that I agree with any of the charges against Randy, but what I can agree is that there is a case before the court right now, and there is a theory of the case I don't agree with, but one that is arguable, that says the Freedom Convoy was an illegal occupation, is what the Crown's theory is, and that participating in it, encouraging it, and not dispersing from it was a crime. So I'm not saying that that's right. I'm not saying that's going to be proven, but I am saying that that is the case that the Crown is hoping to make. And so where that's the case that they're hoping to make, and there is evidence supporting that argument, because the Freedom Convoy is the alleged illegality here, it's totally normal for bail conditions to separate the accused person from that illegality. And so it's actually not a very unusual type of condition to see. I mean, he's alleged to have participated in the illegal action of the Freedom Convoy. Therefore, to get him released on bail, he shouldn't be participating further in the Freedom Convoy. That's normal. That's a normal bail condition in Canada. You could take issue with the way bail is done in Canada, but that's pretty par for the course. And so I wrote to the Crown saying we were prepared to agree to that, but that the him being able to write about vaccine mandates or mask mandates, that there was no connection whatsoever to the offenses that he's alleged to have committed, other than this very roundabout way of saying, well, the Freedom Convoy was against the mandates. He's against the mandates. Therefore, he shouldn't be allowed to, do what the Freedom Convoy, or he shouldn't be allowed to oppose the same things the Freedom Convoy opposed. That's not an actual connection as the law recognizes. Now, the Justice of the Peace today disagreed on that. But what's really important, David, is that there's usually two options. And we actually did a third option today. The two options are usually this. I write to the Crown writes back to me and says, no, we don't agree to your change. Option one is Randy Hillier just sucks it up, agrees to the condition anyway, and then at some point in the future, he can try and change it. But an obstacle to changing it is the fact that, well, you agreed to it to begin with. Option two usually is we haven't reached full agreement, therefore no deal. Let's have a full bail hearing like Tamara Leach did. Let's have a full bail hearing like Pat King did, and let the chips fall where they may. Maybe a Justice of the Peace detains him. Maybe Justice of the Peace releases him on the conditions I wanted. Maybe Justice of the Peace releases him on the conditions that the Crown wanted. Maybe Justice of the Peace releases him on a totally different combination of conditions. Yeah, this is after hearing the sureties testify, the extended legal arguments. I was able to persuade the Crown to agree that because we were so close, and it was really one condition that we had two slightly different wordings of, that we put it before the Justice as a consent release with one narrow issue that needed to be litigated, which was which version of the wording. Would it be the Crown's version of the wording or my narrower version of the wording?
And I'm going to sing your praises for that, but not until you adjust your camera. Tilt your camera down a little bit. If you can, without knocking it over entirely. I know I think you have your phone on your computer screen, probably.
That's right.
Okay. So that's as good as we're going to get, people. So to sing your praises, Dave, because I think everyone strategically has to understand I'll call it awesomeness of what you did, because I'm not sure that many people do. It's very easy to throw the lawyer under the bus. It's very easy for every engineer to come in and say, "Oh, what the last guy did was terrible." When you litigate all the elements, it's up to I keep forgetting the word, officer of the peace. Who the judge? What's the judge's name in Ontario?
If they've got a green sash, it's a Justice of the Peace. If it's a red sash, it's a provincial court judge. Traditionally in Ontario, in Ottawa, it's been Justice of the Peace that have done bails. But in the last 5 to 6 years, there have been many instances where provincial court judges are doing bails as well.
Okay, but this is a Justice of the Peace, and just so everybody appreciates it. If you say we have no agreement on anything, we're going to argue all. You can lose anywhere from one to all for the defense. When you say that We've got we're good on 14 of the 15. Let's litigate the 15th. I mean, that's awesome. What I found stunning, even listening to the call, was that this peace person, forgot it again. Doesn't matter. It's a mental block. This officer of the peace, or the judge, basically brought up other issues that were not before her. The fire or the weapons issue, but we'll get there maybe in a second. But by limiting the debate and saying we agree on the bulk of it, people out there may not like the terms and conditions, but your risk in a highly politicized case like this before judges who it took a rehearing of a rehearing for Tamara Lich to even get onerous release. You're better off, taking what you can leave with versus risking it all. So the 50 that last term was, what could Hillier discuss publicly on his release? And I mean, what did the officer of the peace decide?
So the basically the version that the Crown put forward, which was what was presented to me around 2:30, 3 o'clock, that I said no, we can't agree to that. Again, and I dialed it back to, we agreed to not post about the Freedom Convoy and not support the Freedom Convoy. The Crown wanted those two things, but also, in addition to Freedom Convoy, they also wanted vaccine and mask mandates. So you can't post in opposition of vaccine or mask mandates, and you can't support an organization that is against vaccination or vaccine mandates and mask mandates. So I had argued that had no connection whatsoever to the offenses that he faced, and that a proper application of the Supreme Court decision in Zora was to have a more tailored version of that condition.
And I started off listening to the way that the judge was going. I said, it sounds like the judge gets it. I've thoroughly considered Zora. I've thoroughly considered yada yada. And then at one point, the judge said the strength of the Crown's arguments and the undeniable concerns about, I think it was public safety. I'm like, holy crap! You're on a bail release conditions hearing. And the issue now is this one remaining issue of what a sitting member of provincial parliament can publicly tweet about in respect of issues that are policy issues. Now, people out there are holding against Randy Hillier that he was suspended from Twitter for allegedly violating their medical things. And you may not like those tweets of what he referred to the vaccine as. You may not like it. That's not what he was arrested for, and that has nothing to do with any of the charges.
That didn't come up in the bail hearing at all. The so-called misinformation, as what Twitter had sanctioned him for, that didn't come up in the bail hearing at all. That was not before the Justice of the Peace today.
And I'm gonna pull this one up. CL, not to give you a hard time. Don't agree to any of this BS. Why would you concede a single thing? Hell no. Here's why. Because you saw what the judges did with Tamara Lich and Pat King. And you can fight and you can go to jail, and Randy Hillier can be sitting in a cell right now. And probably get no more favors in 30 days than he'd get today, versus conceding and saying, okay, fine, I deny everything, but you're putting me up on charges of inciting mischief. So it's natural that you tell me not to interact with the members of the alleged mischief on a going forward basis until my trial. You don't like it, but that's how the system works.
I think what your viewers need to understand, I'll use a domestic violence case as an example. I do a lot of domestic cases. And when I say domestic violence, that doesn't necessarily, in most cases, it does not refer to any serious form of domestic violence. I've represented people charged, men and women, charged with things like throwing potato chips in their spouse's face, or
slapping them after a joke that they didn't like.
Well, yeah, not exactly the Will Smith special, but very low levels of violence. And notwithstanding that, even if the person doesn't have a record, even if it's throwing potato chips in their spouse's face, the norm in Ontario, and it's even to a certain degree like this in Quebec as well, the norm is that immediately upon the charge being laid, the accused is placed on conditions that he can't go back to the matrimonial home or the shared residence. He can't have any contact with his spouse or his partner or his girlfriend. And those conditions remain in effect until the case is over or until another court varies that. That's the norm. That because the fact of having any contact with that person is seen as being enough of a risk, that's a standard condition. I've gotten that condition removed in a couple cases in my career, but that's the exception to the rule. And so a situation like this, where an officer is alleged to have been a victim, there are other organizers of the Freedom Convoy. It's totally normal to have them included in people that Randy Hillier can't communicate with. It's totally normal that where there was a large incident that took place in a geographic area, that the accused is told not to go back to that geographic area. And so that's not what people like to hear, but I would be doing my client a disservice if I fought against a condition that I know the norms are that those conditions are going to be imposed.
Azra Sashima asks, can Randy Hillier run for office in June with this? Yes or no? If you know.
Well, one of the arguments the Crown made, and I didn't fully appreciate the accuracy of this argument, but he was saying, well, it doesn't stop him from talking about it. It just stops him from communicating on social media. And again, the Crown, in my opinion, and again, the Justice of the Peace disagreed with me, subject to any appeal, that's the order, and Randy's following it. But the Crown didn't explain, why is it that talking about it on social media is somehow a substantial likelihood of a risk to further offenses being committed, whereas talking about it in a non-social media format it isn't. It wasn't that the Crown making a total ban on the use of social media. It was just on those additional things beyond the Freedom Convoy of talking about vaccine and mask mandates.
But here, Dave, here's why. Because by imposing that limitation, it's easily verifiable in a sense, and it's also easily weaponizable. If he makes any social media post, it will be very easy to weaponize any social media post into having contravened the terms of his release, and his $10,000 bond and his $20,000 surety gets forfeited to the government. I mean, it seems obvious, because I thoroughly think I'm now been blackpilled, that they want it on social media, because if he posts anything, there's a way to say, dog whistle, this is what he meant to say. He was trying to circumvent the order by saying something that we interpret as being anti-mask or anti-vaccine.
I don't like Tim Whiteman, the Crown that argued this case. He's a professional guy. He's a good advocate for the Crown. I really truly believe that he believes in his argument. And again, to a certain point, it doesn't necessarily register with many of the people who are listening and who aren't familiar. But I acknowledged his argument dealing with the Freedom Convoy. I can believe and make the argument on Randy's behalf and run the trial that Randy did not participate in any illegality, or that the evidence fails to establish that the Freedom Convoy was not as the Crown has described it. But I can respect the fact that that's the Crown's theory, and based on the evidence that exists, the court has to give some risk management consideration to that. So I was prepared to go along with saying, look, because the Freedom Convoy is the alleged nuisance that Randy was involved in, that he should be sort of separated from that nuisance as a condition of release. But the vaccine mandates and the mask mandates had no bearing whatsoever to the charges that were before the court. And him continuing to talk about that would have no realistic risk of causing anything.
And how about if he talks about it and someone else posts it to social media? I mean, is that going to be?
I mean, look, and I'm not going to tell you what I say in my advice to Randy, but my general advice to anybody is, whenever you got bail conditions, you always best err.
Yeah, don't talk. And here, by the way, exactly what War Campaign is saying. These bans from social media are to muzzle free speech, not to mention freedom of assembly, by banning them from being with others in person. All organizers and social media personalities are facing the same muzzle orders. RO. I agree. And I'm not, and Dave, I mean, here's the reality. I agree with War Campaign, but I also agree with you strategically, is that this is what happens when the system starts breaking apart, and you're not going to gain anything by saying sit in a jail cell, because you're not going to have any more social media there than you will on these terms. The only issue is how I'm thoroughly convinced people are not acting in good faith. How is someone who's not acting in good faith going to interpret anything Randy Hillier does on social media to be determined? One question people were asking. Sorry.
That's always a concern.
Someone was asking, where did they get the name? This was Karen Cousino says, where do they specifically name Jeremy, Derek, and Greg. It doesn't matter what the names are. When I was listening, I noticed they said you specifically cannot interact with, and they gave very specific names. I just want to read the super chat. Where did the Crown get the names of all the people Randy can't associate with? Thinking of Jeremy, Derek, and Greg. And this is from Plaid Padre. Those names come from anti-hate?
I don't fully know all of the names. I mean, I recognize some of the names, like you saw, like Tamara Leach, you saw Pat King. And so those names that I readily identified are people who are organizers of the Freedom Convoy. And let's pretend this was an alleged drug dealing ring. Okay. Again, I know that this is not, I'm not treating this like that, but let's use that as an analogy for a bit of a thought experiment here. If there's someone who's alleged to be storing the drugs, somebody who's alleged to have been selling the drugs, somebody who's sort of the low-level street dealers, if there's a network of people that are either charged with being related to the same illegality, or some of them might not yet be charged but are persons of interest or being investigated, they want the people who are charged and on conditions to not be discussing this with each other, for the possibility of interfering with the administration of justice, comparing stories, trying to get stories straight. And so, again, say what you want about that method of risk management. That is the method of risk management that is used in cases day in and day out, those with a political nature and those that have not a shred of political elements to them.
I'm going to pull this one up. Russell Wallace Warren, let's pretend, red flag. And Russell, I'm not judging you here. I understand your cynicism. When Dave says, don't change the word let's pretend for operate by this analogy. We are all heavily invested in this. This is why you don't ask the victims of crimes to sentence. You don't ask someone to represent themselves because we're heavily invested. We have our own opinions and we think this is an injustice.
Right.
If you're best friends with someone who's wrongly accused of spousal abuse, it's an outrage, injustice. Why agree to anything? So the let's pretend is, take an analogy that you can distance yourself from emotionally. If this were an accused drug dealer and you know that this person is as innocent as a puppy, you might still feel the same way, but you'll understand still he's accused of interacting with drug dealers in a gang and whatever. And so arbitrarily, imperfectly, but with certain limitations, they say, do not interact with anyone we think is involved in this drug ring. Okay, makes sense. Here, it makes no sense as a matter of fact, but as a matter of law, it applies. It operates by the same rules. You may not like it, and I don't, but you have to understand it, and that's more important.
The purpose of me doing that is, again, because for many people who are following the criminal justice system, they haven't been following the criminal justice system beyond the people who've been involved in the Freedom Convoy. And I want to use analogies that have no political nature to them, nothing to do with Justin Trudeau, nothing to do with a political bent to anything. This is just the way every case is dealt with. And you may feel that I feel in many cases that the conditions in the province of Ontario are often overkill. And I think that, there have been instances over the last several years where the Supreme Court has reined in some of the decisions that are done in bail courts and has seen problems Canada-wide. And I think that we use appellate courts like the Supreme Court or provincial appellate courts to identify problems and to try and fix problems. But all I'm saying is that this way of dealing with it, this type of risk management that goes into setting bail conditions, it's present whether it's a drug case. If there is a fight that takes place at a bar and two friends get together and take a guy out back, and the allegation is they beat him up, they can't have contact with each other. They can't have contact with the victim. They can't go back to the bar. There might be a really good basis for self-defense. There might be a really good basis for it being a consent fight. There may be, on the balance of the evidence, that the two people alleged to have committed this assault are innocent. But because the charges are there and there's enough evidence to lay the charges, the court at the bail phase does not sort out who is guilty or innocent. They put in risk management strategies. So they'll say no contact with the victims, no contact with the co-accused, no going back to the place where this took place. That's just a normal day at the office in a bail court in Ontario. And you don't have to like it, but that's the way it's done in every case.
All right. And I want to say, Russell Wallace Warren, you did not teach me a lesson. Stop trying, stop deflecting. Why did you block me from locals? I can tell you one thing. I personally have not blocked anyone from locals. If someone else or locals itself made that decision, I defer to their rules and whatever. But I've actually, I can tell you this, never blocked anyone from locals, never blocked anyone on Twitter, blocked someone on YouTube for good reason. And that's that. So now, Dave, so I was listening. I tuned in. I tuned in at a moment where they went into deliberation, or the peace officer went and started drafting the decision.
Mm-hmm.
At first, it's like, okay, the judge gets it, and then when the judge just like undeniable proof from the Crown at this stage, I was like, holy crap! I don't know what this last element that was at dispute was, but now I know. But then the peace officer said she raised an issue that no one had raised. Weapons, or it was not firearm specific. I think it was no restriction on weapons. And it was then that I got the details through, I think it was you or someone else saying, well, considering that the alleged assault was committed allegedly with a barrier, weapons were not an issue here. And so we've agreed, I guess, through omission not to include a weapons charge. Can you elaborate on that? What was when they typically include weapons charges or weapons restrictions, what that means?
There's a couple things I can unpack here. I mean, first of all, I have to be somewhat circumscribed in my criticism of the justice. I mean, judicial officers can't respond to criticisms that are made. I mean, as is obvious from the arguments that I made and the possibility that Mr. Hillier is considering appealing the decision. Certainly, it's no surprise that I think her worship got it wrong. But I would say that bringing up the condition in those circumstances was not the best form. I'll leave my commentary on that having been done at that. But I will say that, again, if there was an assault with a weapon charge, or if a weapon was used in a way that wasn't so wishy-washy as in this particular case. Like in this case, it's very hard to see where the assault comes with the barrier. I think, even reading the Crown's own facts, it's a very wishy-washy charge on the use of the barrier. Maybe they sort of allege that he used that barrier, or that the barrier may have inadvertently struck the officer. So, with the evidence being that weak, it would not be surprising for that condition to not be there. Also, when both parties agree on something either being in an order or being left out of an order, a presiding judicial officer, justice or judge, has to give great consideration. I mean, at the end of the day, the justice or judge always has the final say on questions of law. And so if she felt it was totally inappropriate to release him without a no weapons condition, she could have done so, but it would be considered an error to do so unless it was so unhinged from reality. If let's say the allegation was that Randy pulled a gun out and shot at the officer, and we didn't put a condition in saying no possession of weapons such as guns or something like that, it would then make a lot of sense for a presiding judicial officer to say, your decision, Crown and defense, even though you joined and decided you don't want to have this condition there, that decision is so unhinged from the reality of this case that I'm going to put it in there. I mean, we see that type of reasoning in sentences sometimes, when a sentence is either so lenient or so harsh that it is considered unhinged from the reality that the judge or justice gets involved. But that can happen here as well. But when she canvassed it in both parties, I mean, again, to his credit, Tim Whiteman's very professional. He didn't try and finagle that in.
I was nervous because if I'm based on my faith in other attorneys, like, oh, this guy now sees a window to add a 16th condition that you hadn't agreed upon earlier because the officer, the peace officer, opened that door.
Look, there have been Crowns I've come across in my career every now and then who would do something like that. The Ottawa Crown Attorney's Office is full of really professional, hardworking Crown prosecutors. I've been doing cases with Tim Whiteman for probably a decade or even more. And I mean, look, these are the kinds of things where even if you can get away with it and not be subject to any kind of court remedy, these are the types of behaviors which really poison the well for future dealings. And so that type of thing, I mean, I had a case recently where I had worked out the second best deal that I wanted. And what happened was the paperwork ended up coming before the court as the deal I wanted, that the Crown said I can't go that far. And I could have sat quietly and hoped that nobody noticed, but that type of of underhanded play will only come back to get you later on. I think, being honest, being true to your word is the best way. And that's what Tim did. That's what I would have done in that situation. And as a result, the justice of the peace just let it go.
Yep. No, I said the underhandedness, like the all in poker, it works twice, the first and the last time. I'll answer this one, Dave, because I don't want to put you on the spot. If Randy gives a speech and it's put online by whomever, is he in breach because he's not posting it himself? If Randy's in Parliament, doesn't he benefit from total immunity? So, Dave, I don't expect you to give the answer to this. My initial inkling would be, so long as he's not doing it, what other people do is up to them, and they're not bound by the order, and he's not bound by their actions.
I'll even answer it to a certain degree. I think you got it right, but also understand this, that the condition does include not directing other people to do it either. And so even if somebody does it without his blessing, somebody, a police officer, a Crown attorney, could get it in their head that maybe Randy did direct that person, and an investigation could take place. And again, the police don't need to be themselves satisfied beyond a reasonable doubt before they charge someone. They need to have a reasonable basis to believe that there's a probability that this occurred, reasonable and probable grounds. And so that's why I always urge my clients that to try and avoid controversy as much as possible, stay as far away from the fine line as possible.
Yeah.
Because if someone were to do that, somebody could accuse him of being behind that.
Well, and you know what? I took the note down. I want to see if I can find this. There was some phraseology in there that one of the phrases was, he is ordered not to associate. And my note to myself, my note was, what the fuck does that even mean? Not to associate, because it's not to say not to talk to. That's clear. Not to communicate with. That's clear. Not to email, text message. Not to associate. And I believe she even went, and I'm not asking you to poo-poo on the peace officer. Mm-hmm. It's a not to associate directly or indirectly. What in God's green earth does indirect association mean, if not absolute open season?
I mean, I believe it says not to communicate directly or indirectly and not to associate with. Okay. I think the reason why lawyers over the years have done this, and again, this is me just speculating, is that people find loopholes. If I'm told that I can't talk to Viva Frei, I could say somebody else, tell him the following message. If I'm allowed to be in your physical presence, I might inadvertently leave notes without claiming I didn't intend for you to read them, but leave them where you might happen to see them. And so that's why they don't want any set of circumstances that can result in circumventing the intent behind those conditions. So that's why they cover all the bases, say can't communicate directly, can't communicate indirectly, can't associate with. Basically, have nothing to do with this person until either the case is over or until the conditions are changed.
So because I live in LFK, I can only see let's effing
Lanark, Frontenac, Kingston.
Okay. If I do something on my own, this can and even likely so hurt Randy. I mean, don't ask too specific. Dave, don't even answer it. I'll just say, Randy cannot be blamed for what anybody else does. He could, in theory, be blamed if they want to say he put out a dog whistle saying, and I'm not saying that you should go out and post this on social media. I mean, just take it on the scale of absurdity.
Well, you saw what happened to Tamara Leach. The moment she left custody, had her freedom back for 30 seconds, there were supporters of her who were there with their iPhones out, streaming and other things. And she had a condition that she couldn't post things to social media. And instantly, the haters started immediately saying, look, she's already breaching, the fastest breach ever. People will find ways of attributing stuff. So that's why really you got to lead a boring life when you're on conditions. You got to avoid any controversy and really, have a lot of witnesses around and record your interactions, because
record but don't post
you for something.
By the way, I'm not in a bathroom. I can tell you this is a chair, and
I think he means me. I'm in my basement here.
Oh,
yeah.
The guilty conscience, because I've done enough streams in a bath, or I've done enough. Look what you just did, people. Look what you did. I've done enough videos in bathrooms that it's not outlandish to say Viva's in a bathroom. Dave, so you've been working like a maniac, and I feel, I'm not trying to flatter you, I do feel that we are seeing like awesomeness rises for the occasion. Anybody who calls you whatever to say, oh, you're controlled opposition, anyone who says that, follow your Twitter feed. You're not controlled opposition. You're actually passionate, and I think you might be a little more risque than you should be. But that's your life. You're a big boy. And if I may ask you the question, because I think people are going to be shocked. In the chat, how old is David Anber, and how many years younger than me do you think David Anber is? And then, Dave, I'm going to ask you in about 5 seconds. How old are you?
I can't. Can I see the chat?
Yeah. So, people, is Dave, one, Dave is younger, two, Dave is older. And then the question is, let's see this. You know what? One, David is younger, two, David is older. And then the age. Let's just see. Someone says 15.
Thanks a lot, Kathy. 43. Oh my goodness.
28, 20. See, this is where I think people are going to make a lot of mistakes. 37. I think this person might know you. Kangaroo always, no, the qual. 32, 30, 41, 41. Sorry. One is going to be younger than me. Yeah. Dave is younger than me. But I think people are going to be shocked to know how much younger.
I'm 41.
He's not much younger than me, people. Now, the question is it the world that's weighing me down? Do I have wrinkles? I don't think Dave does. I have gray hair that maybe just because it's longer. Dave is 41, so he's not a babe in the woods anymore. Dave's got, like, when he says a decade plus experience, he's got it. 41 it's kind of shocking. It was shocking to me. Okay, so now Randy, now he's got his freedom back, but a highly compromised freedom, which people can love it or hate it. And the amount of people loving it is shocking to me, but set that aside. When you get accused of a crime and you get released on bail, there's limitations on your freedom. That's what it is. Stay in jail pending your trial or agree to certain limitations. I think this is politicized. I think this is purely political. I think it's abusive, exorbitant, excessive, etc. But he's got his freedom. So ultimately, the bottom line of his freedom was, I mean, go over the terms in as much detail as you can go into, limitations and what he can't do.
All right. Well, like I said, there's some pretty standard stuff, like live at a certain address and notify the police of any change of address. Again,
Stop there for 1 second. You reminded me. Is it normal that they mentioned the actual address where he's staying during the hearing?
Yes. I mean, in retrospect, that's probably something we could have tried and asked. I mean, these are public hearings. And so to a certain degree, I mean, people can get the bail orders anyway. I mean, that came out before I had even turned my mind to that they started reading it out. But that is normal. I think, given the fact that there were some saboteurs on the Zoom call that had to be kicked out of the court hearing, that might have been something we could have tried to avoid. But I mean, that just, again,
not to tip people off, but like it's look, back in the day, Dave, we're old enough to remember, we used to have a white pages book. It had a name and an address, and you could just go look in it and find someone's home address. It's very easy. It's a lot simpler than geolocation. It's actually surprisingly easy sometimes, but by and large, the negative players know that already. So whatever. Okay, carry on.
So there's basic conditions like that. There's the conditions to not associate or communicate with either the alleged victim officers or the people who are involved in the organization.
The alleged victim officers. Was he ever going to go like call those officers? Hey guys, you want to go for coffee?
No, but again, it's standard practice that it's meant to give. It's meant not only for the administration of justice, it's also meant to give a peace of mind to people who may have for reasonable fears or unreasonable fears. Again, Hillier's presumed innocent. And so on the basis of his innocence, I mean, and when you mix that with the facts that were read in, it would seem that any fears would be unreasonable. But again, it's a standard risk management strategy to put that in there. Now, looking at some of the other conditions, I'm just scrolling through here really quickly. Not to attend in the Ottawa area between Booth Street and Highway 417.
And for anybody who thinks that's outrageous, he's a member of provincial parliament. I don't know what the address is of provincial parliament, but it's not Parliament Hill. So okay, it's symbolic, but not.
Well, it's Parliament. It does include Parliament Hill of Ottawa, but he's a member of the provincial parliament, so he wouldn't normally be there.
There's by the way, I just posted some of my colonoscopy pics on Kathy's feed. By the way, colonoscopy pics, if you don't know what you're looking at, it's not shocking at all, unless it's a who wants to get grossed out, unless it's not a fully cleansed colonoscopy. And speaking as someone who's had 2 colonoscopies, they were all fully cleansed. But if you want to see some funny stuff on YouTube, okay, too much.
How do we get to this part?
I don't know. Someone posted they put pictures of a colonoscopy on Kathy. Don't bother Kathy Griffin. She's had enough hardships, deserved, but she's had enough. Leave her alone. Leave Kathy alone. Okay. Give, Send, Go is now returning convoy donations. They've already returned them. I noticed it myself, and yeah. Sorry, David, I interrupted because of a super chat about a colonoscopy. So not to attend a certain area of Ottawa,
right?
Not to discourse or communicate with certain individuals. We don't need to name their names. Not to discourse with the police officers who were allegedly assaulted and intimidated.
Right. And then, of course, famous, do not post or cause anyone else to post on social media of any type about the Freedom Convoy, COVID-19 mask or vaccine mandates, or the anti-vaccine cause. And then do not attend or provide any type of support, including financial, to the Freedom Convoy or any anti-mask, anti-vaccine organization or cause.
To me, look, David, it's obvious what it is. It's find bogus bullcrap charges, agree to terms of release, knowing how the system works. This is called lawfare. This is what it is. This is corruption of the modern order. It's not go hire a police officer to plant drugs anymore. You don't need to do that anymore. Just abuse the system. And they're going to silence Randy Hillier. He's been a very vocal person. I might even say more vocal for my comfort level. He says things that I wouldn't say, and that's fine. I don't think it should be illegal. I don't think it should be criminalized. The only cure for misinformation is more information. The only cure for bad speech is more speech. But that's how they're weaponizing the system, and they're doing it very similar to January 6th in Canada in the absence of anything January 6th.
Remember, okay, I'll go on record and say I don't agree with everything that Randy Hillier says. But when you think about it, I don't think of a single human being that I know that I agree with everything that they say either. I think that one of the things that makes our country great and our land great is that we believe in the idea of free speech, the idea that you can disapprove of what somebody says and still fight to the death their right to say it. And I think Randy Hillier has said a few things that he got right about government overreach. And so I think that society is well served by having an advocate like Randy Hillier in many instances. And that doesn't mean you have to agree with everything Randy Hillier says.
No, it's like I had a thought and I forgot what it was. Oh, yes, not agreeing with everything Randy Hillier says. Of course I don't. I don't agree with everything I've ever said. I mean, it's an unreasonable thing to expect. Does him putting out hyperbolic rhetoric referring to, you can go look at his vax tweets. They're hyperbolic. It's not things I would ever say. Criminal? No. Should it be bannable? No. And the issue of keep calling. It's a democracy. If that's criminal, if that can be interpreted as criminal, there is nothing anyone has ever said on social media that cannot be weaponized for criminality. And that's exactly what's going on right now. And that's how democracies fall into banana republics. And I have a dark feeling in me that we are falling into a banana republic. When Trudeau goes to Europe and gets lambasted by the European Parliament, and people say, "Oh, that must be so embarrassing," others rightly point out, when people are cornered and they're cornered rabid animals, they lash out even harder. And that's, I think, what
I got to say this, like, many people contact me and DM me about Trudeau's comments when he said, the unvaccinated, they take up space. Are we supposed to tolerate these people? And lots of people made the same argument to me, saying, doesn't that constitute hate speech under the criminal code? And as a criminal practitioner myself, I was reluctant to want to, I still am reluctant to want to say that is captured by criminal law simply because in his role as prime minister, he has to engage in political rhetoric. But the idea is if what Randy Hillier said constitutes a criminal offense, then if you apply that standard consistently, what Justin Trudeau has said should also be criminally suspect. And so do we want to live in a country where, one, we are routinely holding politicians to account for their rhetoric and accusing and basically silencing speech by bringing criminal charges? And two, do we want to live in a country that applies the standard of criminal prosecutions differently depending on what side of the political aisle you're on? Neither of those two things are desirable. And that's why I don't believe that it requires a very, very high level of conduct, particularly in the context of political rhetoric, to amount to criminal conduct. And what we're seeing with Randy Hillier is for the most part unprecedented.
And here's the thing. I think what Trudeau said, and I agree, I think it doesn't border on hate speech by any traditional terms. It is hate speech.
Mm-hmm.
I don't think he should be arrested for it. I think he should be voted out for it. And I don't think Randy should be arrested for what he said. Hey, vote him out if you don't like it. But the weaponizing of the speech, Justin Trudeau gets out and said, those people are putting us all at risk. They're putting at risk their children and putting at risk our children. The unvaccinated, it is, if you apply it equally, they're identical. I don't think Trudeau should be arrested for it. But the problem is, it drives people into a mode where they say, if Trudeau's doing this to us, we should do this to Trudeau. And I'm not ready to become that monster yet. But to this comment, free speech covers good and bad unless you live in Canada. I'm going to say this, Frank the Tank. Your dog's freaking beautiful. But free speech doesn't cover the good. It covers only the bad because the good doesn't need protection. No one's going to say you don't have the right to say something good. Free speech, by its essence, covers the bad, it covers the offensive, it covers the shocking, it covers the unpalatable, and it covers the unpopular, because no other type of speech would need protection in the first place. And Justin Trudeau has the right to be a racist bigot, an intolerant jackass if he wants to be. He shouldn't be arrested for it. He should have just been voted out of office for it. And now Jagmeet Singh has partnered with that intolerant bigot jackass, and good for you. You become what you hate. But that's my politics aside. Sorry. What's the next step now for Randy Hillier in particular?
All right, well, we'll get disclosure. It'll probably come in a few waves because, for instance, we're going to need to get the videos and the tweets that they say they're relying upon. We're going to need to get the statements of the various officers, that what they wrote at the time, what notes they wrote in their notebooks. Then we're going to need to get these alleged phone calls. They claim that people started making quote unquote malicious calls. If they're going to advance that at Randy Hillier's trial, we need to know what those malicious calls actually were, and were there any that were done to 911 after Randy Hillier made those alleged comments. Again, like I said, there's going to be an analysis for whether or not Randy Hillier committed a criminal act, and then there's going to be a second analysis to see if he formed the intention to do so. So, I mean, all of these things are going to be relevant, and we're going to have to get the disclosure. So that's going to take a few weeks. And then I'm going to speak to the prosecutor, and the prosecutor, I imagine, is going to want him to plead guilty. And we're going to not be so keen on that. And we're going to push back, and we're going to see where it's going to go. We're going to get a judge will look at the evidence sort of in an informal setting and give his or her opinion on the case. And then either we'll reach some kind of agreement, or we'll schedule it for trial where the Crown will have to prove the case beyond a reasonable doubt.
Doss Box Mom says, time to pet Winston to get your blood pressure down. The dog is not here, so I'll find him. Of course, if I find out the dog peed in where we're staying, it'll increase the blood pressure, not decrease it. Okay, so that's Randy Hillier, people. I will be on it like
insert here.
Yeah, there's a bunch of expressions. I realize I can't say any of them. If while we're here, I won't keep you for much longer. Any other cases you can give an update on? We know that you're representing the elderly gentleman who was accosted by the police officers. Have there been any developments that you can disclose in that?
No developments in that. Remember, that took place in provincial offenses court. There's a traffic ticket that was associated with that. I mean, we will be raising issues of unlawful arrest and serious constitutional issues, but that takes place in the Provincial Offences Court, which in Ottawa has not fully gotten back to normal since COVID began. So that's going to take a little while. We've got about a half dozen to a dozen arrests, convoy arrests that we're dealing with. Those just a bulk of them just had their first appearance last week, and some of them are this week, so they're just beginning. And then we have a few other cases sort of kicking around, so nothing really to update you on right now.
Okay, and I'm looking through my notes. Okay, there's that. I'm going to go to Rumble just for 1 second to make sure I didn't miss any Rumble rants. There's no H in Rumble rants, but I shall say it. There's no specific Rumble rants, but I'm going to say, I just want to read some of the chat. Illegal occupation was a damn lie from J Movo. I don't know where they got it from. I don't know how they keep saying it, but they do. Are you going to question the vocabulary illegal occupation? This is Mumsy84. Dude, I've been questioning that from day one, because the only court order that we have in the injunction said abide by the terms and you can protest peacefully. Have you so you must be getting calls off the hook, Dave. Are you getting any social, private or public backlash for representing the Finks that you are representing? And I'm saying that, Finks, as an absolute tongue-in-cheek joke. This is highly political, and you live in Ottawa or you live in the area. Are you getting any public or private social blowback for doing the work that you're doing?
I'll just say this. There are some people who aren't keen on Randy Hillier and don't believe that Randy Hillier should get any kind of defense. And I went into this line of work because I believe that everybody, if you believe in the law, and most people who love to profess their opinions about other people say, well, he broke the law. Well, the highest law of the land says that each person that comes to see me when they're in a situation like Randy Hillier is presumed innocent. I have presumptively innocent clients. That's what the highest law of the land says. So everyone is entitled to a full representation. And I mean, on both sides of the coin, if you believe in law and order and want to see criminals brought to justice, then you want to know that when somebody is convicted, they were convicted after they got a righteous defense and a vigorous defense, so that you know that it was a proper result. And if you're on the side of individual rights, and you want to make sure that presumptively innocent people are not convicted unless the Crown has discharged their burden.
I have a joke to this, Canadian Enjoy Life. Is the Charter toilet paper? I have a joke. I'm going to withhold it because discretion is the valor. What's the expression, Dave? Valor is the better part of discretion. You know the expression, people. The thing with the thing.
You know the thing.
Okay. Oh, say it again.
You know the thing.
You know the thing. Discretion is the better part of valor. You know the thing. Smash the like button. Okay, Dave. So you got to go to bed, and you've got to get up and fight another day. We'll do this as often as we can. I don't expect preferential treatment just because we know each other. But when there's news, let me know so that I can
always enjoy coming on your show.
No, it's amazing. I love hearing it. Because every time I hear it, my stomach turns, in the sense that I know I could not do what you're doing. I was listening to it today. I'm incapable of feigning that pseudo politeness anymore. I can't do it. Mm-hmm. And the sitting there saying, and you have to say your honor or your lordship, you're saying in Ontario. I can't do it. I can't sit there talking to a prosecuting attorney who, as polite as he might be right now, and he might know how to play the game. The insidious level of corruption is that they learn not to be overtly corrupted. And it's just the subtle, it's so delicate, and you have to watch everything that you do. I can't stand it. I prefer the external analysis perspective, but gosh darn, do I have respect for you, Dave, for doing it. And everyone should. And anyone thinking Dave's controlled opposition, why would you agree to anything? You have not lived one day in the practice of law, and even if you have, you're entitled to your opinion. But Dave, people are loving it, so thank you for doing this on such short notice as well. Next time I'm gonna live stream, but not the actual hearing. Earbud in, and I will summarize it. I will verbal tweet, as we say. But Dave, fantastic. If I make it to Ottawa, we'll go for a cup of coffee one of these days.
Sure, and anyone who wants to follow what's going on, just right down here. So give me a follow on Twitter.
I will post. Your pinned comment will be your Twitter feed. Where else can people follow you if there is another place?
I'm not really a big social media guy. Really only COVID-19 policy that got me into Twitter to begin with. I had 800 followers about a year ago. So,
well, dude, you fight the good fight. You're gonna get people who want to see what's going on, but you're vocal and I'm not the real. You're doing the Lord's work in what you're doing. People can disagree with you, but then when they need a lawyer because they get arrested by an overzealous, politicized police department, they're like, oh, hey, maybe I want to call that guy that I thought was an ass from. Oh, hey, by the way, check it out. Booyah! This is how you know you've made it, people. Let me just go ahead. And I'm sorry, I also block Russian sex bots. There's nothing about the Russian part. It's the sex bots. Dave, people love it. Thank you very much. We'll talk soon. And follow Dave on Twitter at Dave Anber with an N, November, not an M like mama.
David Anber, not Dave Anber.
Damn it. It's David Anber or Dave?
Right, like it said right here.
Okay, it's David Anber on Twitter, people. Don't listen to me. I'm an idiot. David, thank you for
verbal typos too.
I make verbal typos. I make reading typos. What is it? Nobody's perfect. Thank you for coming on. Thank you for doing what you're doing. And Randy, I presume, can't give interviews, correct?
He could. I've encouraged him not to, and he's accepted that advice. So
good. Wise advice, even if people don't like it. He shall speak through his attorney. He won't. He's not allowed speaking indirectly or directly through anybody. David, we'll talk for updates in the future. Stick around. We'll say our proper goodbyes. Everyone in the chat, thank you very much. We'll be live tomorrow, undoubtedly. We'll find something interesting to talk about because the world doesn't stop providing interesting content. Nighty night, everyone. Peace out.
Thank you.